Good morning and Happy New Year to all. I'm David Anderson and I serve as Chair of the Behavior Analyst Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic medium. Kimberly Becker.
Here.
Allison Bell.
Here.
Claudia Dozier.
Here.
Linda Heitzman Powell.
Here.
Emily Kessler.
Here.
Pete Peterson.
Here.
Christy Marie Steele.
Here.
Mike Wassmer.
Here.
Alice Jean.
Here.
I note the following BSRB staff members are also present. David Fye.
Here.
Leslie Allen.
Here.
Next, David Fye will read a message concerning this meeting being held remotely.
This is David Fye, Executive Director for the Kansas Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the advisory committee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at this meeting as no individuals requested to provide public comment. Because we are conducting this public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to this meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of the KOMA are not suspended, so we will be conducting this meeting pursuant to the KOMA. On December 13th, 2022, we sent notice of the advisory committee meeting to all individuals who had requested notice of advisory committee meetings. The notice also was posted on the BSRB website at ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting material are posted on the board's website and are available for review. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and the YouTube channel that allow members of the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240 or send an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. And the conference call line is active. I did check that before the meeting. There was no one on that, but I will let you know if I hear someone beep on the conference call line.
Thank you, David. The meeting is now called to order and the advisory committee will begin its discussion. The next item on our agenda is approval of the agenda. Does anyone have any items they wish to add to the agenda? If not, then I would accept a motion to approve the agenda.
I'll make a motion.
Thank you, Linda. Second.
Emily, seconds.
Thank you, Emily. We have a motion and a second. Any further discussion? All in favor of the motion, please say aye.
Aye.
Those opposed, same sign. Motion passes. Thank you. Next, has everybody had an opportunity to review the minutes? Any requested changes to the minutes? Okay, if not, I would accept a motion to approve the minutes.
I move to approve the minutes.
Thank you. Second.
Second.
Thank you. We have a motion and a second. Any further discussion? All in favor of the motion, please say aye.
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 Opposed, same sign. Motion passes. Thank you. All right, we'll move to the executive director's report. Dave.
Thank you, Dave. There's been a few different board meetings since the last time your advisory committee met, so I'm going to summarize some of the action from the board's offsite planning meeting on October 24th, and then talk about some recent actions by the board at their meeting that they just had this past Friday. The board met on October 24th. This was part of an all-day planning meeting. The board seeks to have one of these about once a year. The board talked about a number of different topics. One of those topics was when we have certain applicants for licensure that have not attended a program that is accredited by a national accrediting body, we have an alternate pathway for licensure in most of the professions, but sometimes to consider those individuals, we have to bring in experts to review their coursework or their program to make sure they meet the qualifications for licensure. Unfortunately, we have a limited number of experts to assist us with this, so the board is pursuing some other methods to try to cut down on some of the time of these reviews. There is a company called the Center for Credentialing and Education, CCE, that may be able to assist us with some of these reviews. The board was interested in seeking more information, and so the board is looking at that company to see if perhaps we can enter into an agreement to do some of those special reviews that require an expert. Additionally, the board had been holding license hearings for applicants if they had been denied for licensure in front of the entire board. But based on logistics and scheduling, it was recommended to the board by legal counsel to go ahead and begin using license panels. And these would be made up of 5 board members. So if an individual applies for licensure and is denied, they have the ability to request a hearing. And these hearings will now go in front of 5-member hearing panels of the board. Those hearing panels will be made up of a board member who is for that profession appointed by the governor. If one exists on the board, also a public member, and then 3 other board members can serve on the hearing panels. Additionally, in other agencies and in some other states that have similar programs to the BSRB, they utilize something called an impaired provider program. These impaired provider programs are programs that allow licensees who are struggling with mental health issues or substance use impairments to be able to seek assistance. In some jurisdictions, they use these programs as an alternative to disciplinary remedies to assist individuals if they have a disciplinary item that involves one of those topics. The BSRB does not currently utilize an impaired provider program, but we had heard information recently from one of the providers of a program here in Kansas, and the board was supportive of exploring RFP language to see what companies are out there that might be able to provide assistance to licensees under the board. Additionally, the board had a discussion on reciprocity requirements for the different professions. For most of the professions under the BSRB, there is a main statute that concerns the requirements to get licensure through reciprocity. There's also a bill that passed last year during the 2021 legislative session that provided an alternate pathway for reciprocity for certain members if they were military members, military spouses, if they resided in Kansas or they had an intention to reside in Kansas. And that bill, under the main statute, most of those requirements called for individuals below the clinical level to have served at least 48 months out of 54 in their jurisdiction and then meet other requirements. The military bill has an alternate pathway for reciprocity that has more to do with being licensed in another jurisdiction under a similar scope of practice and having practiced in that jurisdiction for 12 months with some other requirements. And so the board was asked to evaluate if there should be alternative requirements for reciprocity or how they should reevaluate those reciprocity requirements. Additionally, the board was seeking to work on workforce issues. And one of the ways the board wanted to address that was perhaps by individuals who had allowed their licenses to expire in recent years, perhaps because of their health or someone close to them, or because they had stepped away from the profession for some time, but might be interested in coming back to practice if it was easier to do so. Currently, if individuals have a license that is expired, to practice again, most of the professions require that you would pay essentially double the license fee, because you would pay a license fee plus a reinstatement fee. And also you would have to have all the continuing education hours for the previous licensure period before you could have your license reinstated. The board is interested in a new model that would say if your license is expired for over a year, then you would be able to have your license reinstated at half the cost. So it essentially would just be the license fee. Additionally, if you do not have all of your continuing education hours that are necessary to fully reinstate your license, the board was supportive of the creation of a new type of temporary license that would last for no more than 6 months, but would allow you to start working while you're taking those continuing education hours. That would allow you to re-enter the work field faster, and then also be able to have some additional income to pay for some of those CE hours while you're seeking to get your license fully reinstated. And then once you have all of those hours, you can apply to the board for full reinstatement of your license. So hoping that this would be a way to assist with workforce issues by providing more of an incentive for individuals who used to be licensed under the BSRB to come back and have their license reinstated. This would require some statutory change. So this is one of the items that will be going in front of the legislature this spring in bill form. Additionally, the BSRB had some discussions on items involving the behavior analyst profession. There had been a request by the advisory committee for a new board member for the behavior analyst profession. And at that meeting, the board voted in favor of seeking legislative authority to add a new board member to statute. So that would be a 13th board member for the behavior analyst profession. So that would be something that would go into statute. It's something that'll be in front of the legislature this spring. And that will be something that will need to be passed into law. And then once that is passed into law, then the governor's office will have the authority to appoint a member to the board for that profession. So I want to make you all aware of that recommendation. Additionally, there is a statute, KSA 65-7504, which includes disciplinary remedies for the behavior analyst profession. The language in that statute was different from the other professions under the BSRB. For example, most of the professions discuss the board's ability to assess a fine or do a public censure, whereas the behavior analyst statute talked about things like suspending a license or revoking a license, which means that for minor violations, the board is left with limited options in terms of being able to assess the appropriate penalty. So the board was in favor of changing the language of that statute so that the disciplinary remedies would be closer in line with the other professions, and changing some of the terminology in that statute to match more of the other professions under the BSRB. Additionally, the board discussed creation of a new type of temporary license for the social work profession. There are individuals who are seeking licensure who are graduating from programs that are in candidacy from accreditation from the Council of Social Work Education. The CSWE accreditation can take 3 to 3.5 years for programs to complete. So for new programs that are just starting, that are going through that accreditation, it is possible that an individual could go through the entire program while the program is in that candidacy phase of accreditation, and then would seek licensure under the BSRB statutes and regulations. There is one pathway for licensure that says you came from a program that has been accredited, or you have to meet the alternative requirements in our regulation for licensure. However, there are some jurisdictions that view this candidacy as another way that individuals can gain licensure. And so to assure that we're protecting the public, one model that the board looked at was from Minnesota, which allows an individual to get a temporary license while their program remains in candidacy. And then when their program becomes fully accredited, that individual would be able to apply to the board for a full permanent license, just as a normal social work license. And so the board is supportive of this. They're going to be putting this into place for the social work program, but it will have to go in front of the legislature and have to be passed in bill form. So it's a new type of license to allow individuals to be able to practice. Additionally, the Social Work Advisory Committee had made a request to the board.
David, we can't hear you.
You can't hear me?
I can hear him.
Oh, I couldn't hear you. Sorry,
I
it must
can't-
be me.
Yeah, I can hear him too.
Okay.
Okay.
Well, so the Social Work Advisory Committee had made a recommendation to the board for a new requirement in continuing education hours in the area of diversity, equity, and inclusion. You might recall last year, the Licensed Psychology Advisory Committee made a request to the board, and it was put into a bill before the legislature for 3 hours of continuing education in diversity, equity, and inclusion, just for licensed psychologists. That was amended out of the bill when it was in committee, so it did not pass. This year, the Social Work Advisory Committee had brought it before the board, seeking to see if that could be a new addition for the continuing education requirements. The board had a discussion about continuing education requirements for all professions, and I went ahead and researched continuing education requirements in Kansas compared to other jurisdictions. Currently, for all licensees, there is a 3-hour requirement in ethics, and when you look across other states, that is a consistent requirement. Almost all jurisdictions, if not all, require some continuing education in ethics. However, for the levels that are able to diagnose and treat, The Kansas statutes and regulations require 6 hours in diagnosis and treatment for continuing education. And that is a bit unique when you compare to other jurisdictions. So what the board discussed in terms of this conversation, the board was in favor of decreasing the number of hours in diagnosis and treatment from 6 hours to 3 hours, and to add a new 3-hour requirement for all levels of license that would be in cultural diversity. And so for individuals who are able to diagnose and treat, this would be 3 hours less in the diagnosis and treatment continuing education, and 3 hours as a new requirement in cultural diversity. For individuals who are not able to diagnose and treat, they would still have the 3-hour requirement in ethics, and then a 3-hour requirement in cultural diversity for continuing education. And these are not on top of the existing continuing education hour total requirements, such as 30 to 50 hours, which is what the different levels of licensure require. Just has to do with the number of hours targeted within that would have to be in certain categories. Additionally, the board made a recommendation for a change to the professional counseling regulations. For that profession, there was language in the regulations for licensure that noted individuals seeking to gain a license for professional counseling had to have obtained a degree in professional counseling or a related field. But the requirements and the regulations for those programs indicated that the person who was chairing or directing the program had to have a doctoral degree in professional counseling, but there was no language to allow for the person directing the program to have a degree in a related field. And so the board was in favor of expanding that. And so the board made a change to recommend that the person directing or chairing the program could have a doctoral degree in professional counseling or a related field. Additionally, last year and this year, the board has had discussion on records of deceased practitioners. These would be situations in which you would have a solo practitioner in most cases who might pass away unexpectedly, and the question would be what would happen to those records. And these also could be records that would be abandoned in certain cases. The board made a recommendation that the first step in this process would be to go ahead and have language added to the unprofessional conduct regulations for the professions, establishing that it is a responsibility of practitioners to have an alternate custodian of their records identified if they are not working for a company that would have custodianship of the records. And then once it's established that there would need to be an alternative custodian of the records identified, then the board could move forward on ways to verify that, such as by putting questions on a renewal applications to verify that the person was in place in case there was a question of who would be the person to have custodianship of their records. And so this is something that will go into the regulations coming up, but that's one way that the board was seeking to provide assistance to this method. Additionally, the board met on November 14th and heard a presentation on the Professional Counseling Multi-State Compact. There was a representative from the Kansas Counseling Association who spoke in favor of that compact, and the board was able to receive information on the compact. This has been in front of the state legislatures for the last couple of years. 2 years ago, it was passed by 2 states, and then this past year it was passed by about 15 others. So it has reached the threshold for that compact to begin to meet. It has not come before Kansas yet, but the board did receive information that it will be requested in terms of bill form this year, and the board is asked to take a position on that in terms of if they would support the compact. Additionally, the Kansas Fights Addiction Grant Review Board was established by the 2021 legislature. It began to meet in 2022. The board had appointed me as a temporary person to serve on behalf of the board on that grant review board. The board had opened it up to other individuals in terms of naming a permanent appointee to that grant review board. And we had a few individuals submit materials. The board reviewed those, and the board appointed Jason Hess to serve as the new appointee to the Kansas Fights Addiction Grant Review Board for the BSRB. His term will last for about 1.5 years, and then the board will revisit reappointing individuals to that grant review board about every 2 years. Additionally, the board made changes to the investigation policy that guides the work of the Complaint Review Committee. Those changes were updated, and then the board made a couple more changes at the board meeting that happened this last Friday. So that new policy will be posted to the board's website here shortly. Additionally, the board made a decision to go ahead and increase some authority for individuals to seek extensions of time if they had not completed their continuing education hours. We had discussed in previous meetings a regulation for the licensed psychology profession, KAR 102-1-15G. in which licensed psychologists, if they were coming upon their expiration date, had not completed all of their hours, they could make a request to the board for additional time. If they were approved, they could renew their license and then get additional time to complete those hours. Most of the professions were in favor of expanding this to the other professions with a few changes. One was for the amount of time that they could have to be decreased from about 6 months to 3 months. Second, they would previously would have to show good cause for needing the extension. Under this change, they would need to show extenuating circumstances for needing the extension, and also they would not be able to use this request for an extension in back-to-back license periods. So we are working on putting that into place to allow more individuals to stay licensed if they are encountering something that was unexpected and extreme, such as something to do with their own health or someone close to them, or a situation sufficiently beyond their control. Additionally, there is a requirement in some of the professions regulations, primarily for the alternative pathways for individuals who did not attend a program that's accredited by a national accrediting body. Some of the regulations required that a certain amount of their coursework had to be received while they were in residence or physically present at the institution. And for online schools, that's a standard that really can't be met. And so the addiction counseling, marriage and family therapy, social work professions all made a recommendation to the board, and it was confirmed by the board to go ahead and remove the physical present requirement for the in-residence and to allow the face-to-face contact by screen in front of core faculty to be met either in person or by screen. And then at the last meeting that we had this past Friday, that was also a recommendation that was made by the Professional Counseling Advisory Committee. In terms of some legislative updates, there's a number of regulations that recently went into place for a number of the professions. Those had been going through the process this past year and were posted on the BSRB website. There was an open meeting on November 8th, but no oral or written comments were provided. Those have now gone into effect as of December 16th, 2022. Most of those involve individuals who are trying to seek a clinical level licensure, who are submitting training plans. And so a message was sent out to all licensees concerning those updated regulations. Additionally, I presented testimony at a legislative committee meeting about 2 weeks ago on December 21st. This was a group that was looking at workforce issues concerning mental health beds, and I spoke about some of the discussions and the work that the board is doing concerning workforce issues. In terms of the board meeting that took place this past Friday, the board did go ahead and recommend that if their multi-state compact for professional counseling is introduced, that the board would like me to introduce testimony in favor of that compact. So the board is supportive of joining that professional counseling multi-state compact. Additionally, the board entered into an MOU for legal services from the Department for Aging and Disability Services. KDAS is going to be providing the board legal services in terms of board counsel and disciplinary services through their office. We are looking at changing some of our legal counsel services for the agency, and we should have more information on that this spring. Additionally, the board had a discussion on reciprocity requirements for the different professions, and the board did make a recommendation to seek statutory changes to drop the number of hours for reciprocity down from someone practicing in a jurisdiction for 48 months down to 12 months, which puts it more in line with the time frame for that alternative reciprocity pathway that was passed in that military bill that passed last year. Additionally, the board made a recommendation to put forward a new type of student temporary license for addiction counseling. This would be for individuals who have a certain number of hours who are seeking to satisfy all of the required hours for a licensed addiction counselor license, but they would be working in a supervised position, and they would be they essentially would have an attestation from an employer who indicates that they'd be willing to hire them for that position. And so they'd be working under supervision, but they would be still a student prior to receiving their bachelor's level addiction counselor license or one in a related field. So that is a new type of temporary license going before the legislature this year. And we are hopeful that it will pass, and then we can begin to implement that here shortly. So with that said, I will go ahead and end my report, and I can stand for any questions.
Thank you, Dave. A lot of information. Does anyone have questions? Yes, Linda.
Yeah, so the reciprocity that you're talking about, is that part of what we're going to talk about in our meeting today because it's on the agenda?
Yes, so
Okay.
the board has had some conversations on reciprocity for the other professions.
Mhm.
There is not a main reciprocity bill or main reciprocity statute for the behavior analyst profession. There is a way that individuals can gain licensure through reciprocity for the behavior analyst profession under the military bill. But that has to do with language in that bill that says if there is not a reciprocity statute in your jurisdiction, then they will consider you under that bill if you meet the qualifications for that bill. So
Mhm.
I wanted to go ahead and open it up to have a conversation on perhaps a statute for the behavior analyst under reciprocity.
Thank you.
Other questions?
And David, it looks like Mike has his hand up.
Mike, are you there? Mike, did you have a question?
Yeah, sorry, somebody was at my door. Hang on. And I'm sorry if somebody asked while I was gone, but in relation to the recommended change in the CEU hours, I mean, I'm all for adding something related to DEI, but did I hear correctly that you're recommending decreasing the number of hours related to training? Or and what is the status of that recommendation, and who is that coming from?
Yeah, so what I did is I did a survey of different continuing education requirements across professions, looking at other states, and in terms of how our standards compare to those in other states. And so almost all states, if not all of them, have a requirement of ethics, but our requirement of 6 hours in continuing education and diagnosis and treatment is a bit unique. Now, some other jurisdictions do have requirements in other categories, such as DEI, but the 6 hours in diagnosis and treatment was a little unusual compared to the requirements for other states.
In what respect?
A lot of states don't have a specific requirement in diagnosis and treatment. Some of them, I mean, it could be something that you could get within your hours, but in terms of having a specific number for that purpose, we appear to be a little bit of an outlier concerning what other states would require in that area. And so the board talked about other topics that are considered, other states maybe have 3 hour or a certain number of hours in DEI or suicide prevention or, working with military members or different things like that. But our diagnosis and treatment was a bit unique. And so they thought in terms of, they also didn't want to limit the number of hours that individuals could get within their total number of hours. So they saw the benefit in requiring hours in cultural diversity, but didn't want to have too many of the hours prescribed. And so they recommended to lower the number in diagnosis and treatment down from 6 to 3 for those that are required to get them, and then include a new 3-hour requirement in cultural diversity. So,
And that's for psychologists or the psychological field, right? That doesn't specifically pertain to behavior analysts?
this would be across the board for everyone.
Okay.
I was going to add that behavior analysts don't have the requirement of diagnosis and treatment, so that part doesn't affect them in their CEUs.
Thank you, Leslie.
Uh-huh.
Yeah. So for individuals, for the levels of license that aren't able to diagnose and treat, they only have the 3 hours of ethics. So it would be a new 3-hour requirement in cultural diversity. For the levels of license that previously had a 6-hour requirement of diagnosis and treatment, it would be decreasing that from 6 to 3, and then having a new requirement of 3 hours in cultural diversity.
And when does that start, David?
So that would need to be something that would be passed by the legislature. So if the legislature would go ahead and put that into place, I believe probably the earliest we would be looking to enforce that would probably be July of 2025, because I believe we would want to give a 2-year license period so individuals would know what's expected when they come up for renewal.
Yeah, and that'll probably make itself in line with the BACB because I'm pretty sure that they're going to start requiring that as well at some point in time. Is that other people's understanding?
The diversity, the DEI, yeah. Not so much the diagnosis and treatment because
No,
that's
they want, yeah, that's not going to be a specific requirement. I mean, that's essentially what most of our CEs are, is treatment. So,
Right.
But I'm pretty sure that the BACB will be moving forward with a DEI requirement.
Just a reminder, Dave, that the licensed psychologist had requested that in the previous legislative session, and that was taken out by the legislature, correct? So even though we've recommended that the board has recommended that, it doesn't mean it will survive the legislative process.
That is true. And this is a little bit different. The previous bill was for just the licensed psychology profession, and it was 3 hours in diversity, equity, and inclusion. This would be 3 hours that would be in cultural diversity, and the language that the board was in favor of using has to do with a 3-hour requirement cultural currently for psychologists in Texas. And what they had down is the definition of cultural diversity would include but not limited to professional development regarding age, disability, ethnicity, gender identity, language, national origin, race, religion, cultural, sexual orientation, and socioeconomic status. So the last language specifically said diversity, equity, and inclusion. This is cultural diversity, that definitely closely related, but the definition, one of the questions that came up last year in those meetings was looking for a definition. And so this time the definition would actually go into the statute as well to provide some clarity. But this is something that would need to be passed by the legislature before it would be a requirement.
That's probably a smart call, the change in the name, given the state we're in.
And as Dave has explained in the past, we put forward kind of our recommendations, but once we give it over to the legislature, we kind of lose control of that. And we've had other issues beyond that one that have been removed or modified without our feedback. So it's always important to remember what Dave talks about in terms of what we send to them isn't necessarily how things will exactly turn out on the back end of the legislative process. Other questions from Dave's report? All right, if not, we'll move on to old business and the finalization of recommended changes to unprofessional conduct regulations.
So as you might recall, last year, I had asked each of the advisory committees to review their unprofessional conduct regulations to look to see if there's any language that is missing or any language that may be vague and needs to be clarified, or any language that can be removed. And I appreciate all the work that you all did. A number of you took on different types of work, looking at different criteria and comparing the unprofessional conduct regulations to the ethical code of the BACB. And so what we are asking each of the advisory committees now is to take all the work that you have done and to try to finalize it into some recommendations that can be forwarded to the board as recommendations. And then the board could have a discussion this year in terms of perhaps some of those changes that would be specific to a profession, or some that could be maybe across the board changes that would make sense for uniformity. So I went ahead and forwarded 4 documents, and I know that there's a lot of different conversation on different points. So what I have done is I put together a table using 2 of the documents. There were 2 documents that were essentially taking the unprofessional conduct regulations and the record keeping regulations with some notes on possible changes. And so I went ahead and took those 2 documents and I put them into a table where you can see side by side the current existing unprofessional conduct regulation next to a possible or proposed change. And so I did that for 2 of those documents. And then for the others, I thought perhaps the individuals who worked on those spreadsheets might be wanting to walk through and have a conversation. And so hopefully we can reach some consensus today on possible changes, and then those could be sent to the board for consideration. So I think as a first step, I'll go ahead and share my screen and we can take a look at that chart. And so you should be able to see a table right now And just for reference, the main comments I had were from a document that Claudia Dozier had worked on. And so we can kind of walk through these to see if there is consensus on making these changes to the unprofessional conduct regulations. And then there was one at the bottom that had to do with a separate regulation that was on record keeping. I can tell you for most of the professions, there has been a recommendation to go ahead and combine the record keeping regulation into the main unprofessional conduct regulation. That way it's all in the same place. But perhaps we could walk through these and then see if there's consensus on this possible changes. So, and just for reference here, unprofessional conduct for the profession is in KAR 102-2 or 102-8-11. And so here, item H, the current language says that it would be unprofessional conduct to offer or to perform or performing services clearly inconsistent or incommensurate with one's training, education, or experience, or with accepted professional standards. And the possible change that was suggested was to add language following this that would say soliciting testimonials from current clients or stakeholders for use in advertisements to obtain new clients. And if you do have suggestions, feel free to go ahead and just kind of vocalize them. With the screen being shared this way, it may be difficult to kind of see if someone has a hand raised. So.
Okay, I think what Claudia was saying, and correct me if I'm wrong, Claudia, is not to change H, but to add something after H.
Okay, so this would be a new regulation then.
Yeah, like it would be I. Okay. Instead of H, it would be I, and then it would cascade down from there.
I have to look at what I specifically said. Hold on.
Yeah, I'm looking at it, Claudia. And that's
like some of that I just suggested changing the wording within whatever was listed. Some of them I suggested adding something after. So in my documents, if I suggested adding after something, I said after, I would have said after H, add this, but I didn't hear. So I think it's just suggesting changing in the language.
Well, Claudia, you say after H, add soliciting testimonials from current clients or stakeholders for use in advertisements. So
gotcha. Yeah. If that's what I said, then that's what I've meant.
Yeah.
It's been so long.
What you say. Because let's see, offering to perform services. Yeah, because it's two different things. The H is we don't want people offering to perform services that are not commensurate with their training. But also, according to the BACB, we can't solicit testimonials from current clients or stakeholders in order to obtain new clients.
Okay, so is it consensus to go ahead and add this item as a new regulation?
I'm always a little fuzzy on this one. I mean, just to be transparent, because I've had people that have wanted to be involved in fundraising activities because their kids receive services and they're like very pleased with the progress their kids are making, versus having those ads on your website that say, John Doe says this is the best place to go to get services. Please come get services from us. So so I've always been a little fuzzy on this. Does some of the BCBAs on here want to pop in?
What comes to mind for me is we talked about how the difference between the ethics code through the BACB and these unprofessional conduct regulations, or that these unprofessional conduct regulations are the more egregious offenses. And so that's what I think about here is does this fall in line with those more egregious offenses, or is this more like best practice? in relation to ethics.
Any other thoughts from advisory committee members?
I was just going to say, I don't disagree that we should have something. I think that I've seen this, especially for some of our for-profit businesses that are in Kansas. And I guess because they think they're a business, they don't have to follow this, but they have behavior analysts that work for them. So I don't know. I really feel like we should have something.
I think that's Kimberly, you have a really good point about the business side, but also behavior analysts who work for them. So, well, I guess I'm just thinking about those behavior analysts who work for-profit organizations. What will be their choices are if their organization is doing those, and how we are going to be able to enforce that as an ethical conduct.
That's a good point.
So I've run into this in the past. And what we did is make your adherence to the code known, and then you document your attempts to have them take down whatever it was. And then, I mean, it's up to the behavior analyst kind of what their next steps are on that. But they need to have documentation that they've at least asked to have those things removed or asked to have it identified in the correct way.
And that's not something that we can put in here. So I've had things come up before, specifically with regards to authorizations. And the response from the board was that the behavior analyst worked for the insurance company. That was their employer. And the behavior analyst certification board couldn't dictate to the employer what they could do and what they could not do. But specifically with regards to authorizations, the BACB came back and said that that behavior analyst then could not represent themselves as a BCBA in advertisement, right? So, but that was a while ago. That's been like, 10 years ago. So, so my question would be to the BSRB folks, then how do you handle that if you have an agency that is soliciting testimonials, but you also have a behavior analyst that works for that agency?
As a general guidelines, our jurisdiction is over the individuals. So in terms of agencies, we don't have jurisdiction over the agencies themselves. That comes into play sometimes when it comes to someone who wishes to file a complaint against, let's say, an addiction counseling facility or, another group. But on an individual level, it would really be our jurisdiction is between the person and their license. So that's one thing. And in terms of the interpretation, each of these things would come down to the members of the complaint review committee seeking information if there's been, a complaint towards someone, if they violated something, and then they would just look at all the information as a totality type of review to see if they may have violated one of these unprofessional conduct regulations. So we don't usually provide general, guidance proactively in terms of what would constitute a violation or what wouldn't constitute a violation. So that's why it's helpful to make sure we have clear language here so that individuals have an understanding.
Yeah, and I agree with that. I agree with adding something in here. I just don't want to set up our individual behavior analysts to be at risk if they work for a company that does this, right? That's putting them at risk. So I don't know the answer to that question. I guess it's a
I
conundrum.
assume that if they don't do it, then they're not at risk, right? Just because they're associated with a company that does it, it wouldn't seem to me that would be a violation.
So then, like, after H, add soliciting testimonials, blah, 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 would it reduce individual risk if we said personally soliciting testimonials? I just feel a little bit protective about behavior analysts that are out there trying to do a good job. But if we add in personally soliciting testimonials, then I don't want to absolve them of guilt if they endorse their company, but it makes it a little bit more clear that this is related to the specific professional.
Or maybe directly soliciting.
Yes, I like that language better than personally. And then, David, if you would change, instead of possible change from Claudia Dozier, put in there possible addition following H.
Okay.
Thank you. I'm comfortable with that.
So it would read, offering to perform or performing services clearly inconsistent or incommensurate with one's training, education, or experience, or with accepted professional standards. And then you'd probably want to say something like including directly soliciting testimonials from current clients or stakeholders for use in advertisements to obtain new clients.
So I guess then the question is, do we want it as a part of that or as a sub?
This is Leslie. I thought you were saying it was a new subsection.
Yeah,
Yeah, based on the wording, it may make sense to go ahead and have this as a new item.
yeah, that's what I think. Either a new item or a subsection, but I think it's two different things. I think I could go out and say, yeah, I can like teach your child how to perform quantum physics when I know nothing about quantum physics, right? Versus
Okay. Well, is it the consensus of the advisory committee to go ahead and add this as a new language to the unprofessional conduct regulations?
Yes.
I'm good.
Okay.
Yes.
Any objections to doing this? Okay. Item number 2, under J, discriminating against any client, student, directee, or supervisee on the basis of age, gender, race, culture, ethnicity, national origin, religion, sexual orientation, disability, language, or socioeconomic status. The possible change was adding language, failing to actively engage in professional development activities to acquire knowledge and skill related to cultural responsiveness and diversity.
Do you want me to speak for you again, Claudia?
So this is in the BACB guidelines, but there's no requirement currently by the BSRB or by the BACB to have CEs in this area. So I don't think it's necessary to add it unless someone else feels strongly. Plus, there's no way to evaluate it.
The only
How do
way
you
to
evaluate whether
evaluate it,
someone actively engaged in professional development activities if it's not a CE requirement?
but isn't this what we were talking about a little bit earlier, though, where they would be required to have 3 hours? We would be.
Yeah, but that
required-
wouldn't be until July 2025.
Oh,
And there's nothing from any entity that's requiring that right now.
I agree with that, since we don't have a requirement.
So is it the consensus to do not add this one at this time.
Which is unfortunate because it's important.
Agreed.
David, one of the
But
first.
I mean, the regulation that's currently in there, like it essentially indirectly covers that, like ensuring that people aren't being discriminated against. Not everything, but
I
On
would
a
think that
related,
this language would be in, if you wanted it required, it would need to be in the regulation. It wouldn't be in unprofessional conduct.
And Leslie, do you mean in the continuing education regulation?
Yeah,
Okay.
because it just doesn't seem like an unprofessional conduct violation.
I agree. If they are like, if there is a requirement on CE at some point, then failing meaning that they won't be able to get renewed with their licensure. So
agreed.
one of the first things we talked about in relation to this regulation was to update the protected classes. Is that addressed elsewhere, David, or did that fall off the radar?
So I went ahead and just took the notes that were on Claudia's sheet. And so if there were separate ones in those Excel spreadsheets, it's possible they might be mentioned there, but I didn't see a note on her sheet. So
Okay. Well, I'd like to put that back out there as adding in disability, gender expression identity, immigration status, marital relationship status, and then the clause at the end, or any other basis prescribed by law, to match what the BACB also has and what's best practice currently.
okay, is everyone else in agreement with that change?
I do, and I'm wondering if Claudia's, like part of these, J specifically is discriminating against, right? Claudia's comment, failing to actively engage in professional development activities, almost falls more under under H, which is if they offer to perform a service that's inconsistent with their training, you shouldn't be working with people unless you have training or experience in that field, right? But
Leslie, I thought you weren't adding that.
it's just another comment that we need to have it, but it might fall underneath that H. And all right, I'll stop.
No, I'm sorry. I understood that you weren't adding that language at all. The Claudia's additional language.
Yeah, I think it's kind of clarifying more under H instead of J, because J is discriminatory, and I like Christie's addition to J. I think until we get the continuing ed CE requirement in, that it's fine.
Okay, so what I'm hearing is for right now for J, not to add the proposed language, but for the different groups that are listed under J to go ahead and add the other ones that were mentioned. Okay, sounds like we have consensus on that one. Under K, failing to advise and explain to each client their respective rights, responsibilities, and duties involved in the licensee's professional relationship with the client. There was a note to add in understandable language. I just kind of wanted to highlight that to see if there are some additional comments on that.
Yeah, I was just suggesting that based on the BACB information, that when you advise and explain, that you use language that's understandable to the client or the stakeholder.
So would it be something like failing to advise and explain to each client in understandable language the respective rights, responsibilities?
Yes.
Okay. Okay. Any other thoughts on this one, or any objections to this one? Okay, sounds like we have consensus to go ahead and add this one. On number L, language says failing to provide each client with a description of the services, fees, and payment expectations, or failing to reasonably comply with that description. And the similar comment would be to add in understandable language. And so any other comments on that one, or any objections to adding that language?
I feel like in understandable language is very important. I still feel a little bit confusion with this particular item, just because of the as a behavior analyst, I don't know how often a behavior analyst would be able to explain the fee structure and the cost of an insurance like directly. Maybe it's just because I work at HUMED, and then there's such a big system, and a lot of times have no idea how much that costs to the client. But so I don't know how everyone else is thinking about that.
When I was at Heartspring, I had a clause in our contract that just says that they have discussed the fee agreements and the fee details with our business office. And now that I've run my own practice, it's part of our intakes that we're discussing those things. And so I think you can do it either one of those ways.
Okay. Any other comments on this one, or any objections to go ahead and add in that language? Sounds like there's consensus. Under M, the current language says failing to provide each client with a description of the possible effects of the proposed treatment if the treatment is experimental or if there are clear and known risks to the client. Possible changes were either add in an understandable language, and also after M, add failure to take appropriate actions to address errors or lack of follow through on commitments in the best interest of clients and respective parties.
Claudia, did you mean lack of follow through on the parent part?
No. So that's directly from the BACB. So failure to take appropriate actions to address clinician errors or lack of follow through on commitments that are in the best interest of the client and relative parties.
So meaning if I say I'm going to do an FBA and then I don't, that would fall under this.
I'm not sure. That's the BACB language.
Okay.
I think it's so broad. I'm not sure I would add this.
Yeah.
There's so many sections that are already in this with respect to best practice and, client best practice and stuff. I don't know if we need to add it.
In relation to this clause, what we did talk about previously is that about the term experimental, that behavior analysts wouldn't be engaging in experimental practices unless it was research-based, so that this clause may need to be rewritten. So the original recommendation that I had was rewriting it clause M to say, failing to provide each client with a description of the proposed treatment procedures, anticipated outcomes, and possible risks to the client.
That sounds good to me.
I agree.
Okay.
In understandable language, maybe.
Right.
Love that addition.
Okay. Any other comments on that one?
So where is that language being written down so that those changes can be made? What Christy just said.
It's in that Excel spreadsheet.
Okay.
Yeah, and I will go back and using some of this as a timestamp to go back and make sure we have that language here.
Okay, cool.
We'll have, so it sounds like the consensus is to have an understandable language added and then to rephrase item M based on the way that Christy just mentioned it. So, okay. Any other thoughts or any objections? Okay. Item S, engaging in professional activities, including billing practices and advertising involving dishonesty, fraud, deceit, or misrepresentation. Possible addition after S, has derived or solicited any form of monetary profit or personal gain as a result of their professional relationship with clients or relevant parties, with the exception of unsolicited token gifts. And I'll mention on this one too, some of the other advisory committees under S have talked about engaging in professional activities, including billing practices and advertising. Some of the advisory committees have recommended adding, including but not limited to, billing practices and advertising, just to show that it's not intended just to be limiting to those two. They're just highlighting those two.
I like that.
What about the other language that was mentioned here concerning the monetary profit for person or personal gain? Any thoughts on that other language that talks about, with the exception of unsolicited token gifts?
I'm probably being dense here, but could we define unsolicited token gifts? Because I'm thinking somebody's going to read that and not understand it. And again, I'm probably being dense.
As a technical matter, it could be defined. It just kind of comes down to a choice. I'm not sure what the definition of that would be. Sometimes it is helpful to not have everything defined, so that way you can weigh different things, but that also kind of, it is helpful to have a better understanding of things going into it to make sure you're not violating any kind of unprofessional conduct standards too. So
The only reason I'm asking is because, again, we cross-section so many different areas. Like, as a BCBA working in schools, it's very typical that teachers or other people would get gifts. And so where is the line that it becomes and of course that would be unsolicited potentially, but I guess where is the line that, is a $50 gift card from Starbucks crossing the line?
Doesn't the BACB define it at $10?
Yes.
So maybe that's where maybe we can become a little bit more clear. And again, that's just me because I just walking in different walks of life, it's very easy to not quite know on that one.
And part of the difference here, and this is where things get really fuzzy, is that as behavior analyst working in the school, you're not subject to these regulations because you're not billing a therapy.
Correct.
You're right. I'm sorry. You're right. I forget about that. Thank you.
I wonder if we took out the gifts altogether and just put any form of substantial monetary profit or personal gain. And then that way it still leaves some room for conversation. But if it's not a substantial gain, then it would be an exception here. It wouldn't apply here. Because I could also see it going the other way where it's like, well, I didn't solicit this yacht that the family bought me.
I want that family.
And so that,
So this language I took directly from the Missouri law, from the Missouri regs.
I agree. Part of the way that I've handled this, like out in the field, because people send gift baskets, right? Which, cost more than $10. So the office, then, the office staff gets that. And I say, or if they, give a toy or something or a gift card, I'll say, I'll use this to purchase stimulus materials for other families. So it's not a personal gain. There's got to be, especially for some cultures, if I returned it and said, sorry, I can't take this, that would be disrespectful. So in the past, that's how I've handled it. I would like to continue to be able to do that. So
Yeah, I think it's just best to keep this language vague. It's a lot more specific in the BACB ethics. So I think for here, it's best to keep it vague, because if not, we're gonna have to be changing this every single time the BACB changes the monetary requirement, what's okay and what's not. So
I agree.
And I'm fine with that. Again, it was more just having this conversation to remind myself. Again, all of this comes back down to professional development, right? And so thank you all for giving me a little bit of professional development and reminding me of that. So I'm good with the vagueness.
Does the suggestion of the substantial monetary profit or personal gain, does that feel qualitatively like that? Does that not fit as well for what you guys are thinking for this language? Because I understand it's what Missouri is using, but it doesn't necessarily mean we need to do it the same way.
I like the wording, but if folks want to change it, that's fine with me.
So I'm trying to take into account.
I'm sorry.
Go ahead.
Okay, I was say, so can we also change the personal, like replace it to like any form of personal monetary profit or gain? Because I felt like if it's, I think the thing is like it cannot be benefiting that person or that clinician, right?
Yeah, let me make a modification here and see if this kind of matches some of the comments. And then what would we think about with this? And then just take out the note about the token unsolicited gifts. So that way it would say has derived or solicited any form of substantial personal monetary profit or substantial personal gain as a result of their professional relationship with clients or relevant parties.
Works for me.
Okay. Hearing no objection, sounds like we have consensus. So AA, the current language is soliciting or assuming professional responsibility for any clients of another agency or colleague without attempting to coordinate the continued provision of client services by that agency or colleague. Possible change was to add after AA, when entering a relationship with a third party, failure to clarify the nature of that relationship with each party and assess any potential conflicts. Any thoughts on this one?
Basically, this is not stealing clients from other people, correct? As it's currently written. Is that correct?
I also wonder whether it would fit into a situation like you're working with a client and then the client is seeing other therapists already, like maybe seeing a psychologist, and whether you are collaborating or coordinating the services. I think that would fit into that description as well.
I think that's different. I think the way it's written now, it's, I won't steal clients from you, Alice. Right? Soliciting or assuming professional responsibility for any clients of another agency or colleague without attempting to coordinate the continued provision of client services by, so not assuming professional responsibility for your client without trying to coordinate continued treatment by you. I think that's how it's written.
Looking back at my initial review of these, my recommendation here was to clarify or simplify the wording, because it also, I didn't understand what it was saying either, as it related to coordination of care when you're
Right.
taking on a new client, or what is the function of the clause. And if you're unsure too, Linda, then it sounds like we have a problem in that
Yeah.
our certificate or our licensees aren't going to understand either.
Yeah, because I think they're two separate things. There's often times when you have home-based services and you coordinate with the school, right? And collaborate with the school, or vice versa, or the speech language pathologist, right? And you each have a part of the treatment responsibility for this client. So you're going to coordinate with that other professional to address any potential conflicts as a collaborative entity, versus I'm not going to solicit or assume professional responsibility for a client of another agency without, making sure that person or that agency still has the care oversight for that individual.
I think this description is of course very confusing. Just Linda, to what you are saying there, like you do not, but because part of the language is also assuming professional responsibility. What if a parent decided that they're going to end the services and then they want you to be the BCBA? Am I still responsible to try to contact the other agency that they are leaving and trying to coordinate?
Well, I look at that, Alice, like here at the Bridge Clinic, we have the kids and we transition them to their long-term home out in the field. Mm-hmm. Coordinating with them, that's a collegial relationship. I'm going to coordinate with the accepting agency. We're going to transition all their criterion referenced assessments and goals and progress notes to the accepting agency. That's a collegial collaborative relationship, right? And I think I think that's important, that I am open and transparent with the receiving agency when clients are transitioning. And I would expect that the same would be true in reverse. I think that's different than what AA is saying. I think AA is saying that I'm not soliciting, and I guess the assuming professional responsibility. Yeah, if the parent wants to change, how does that fit in with that? Thoughts, anybody? And I've had people that refuse to give up, like the Ables before.
I feel like I just don't know what this AA is trying to do.
So essentially what it's suggesting is that, hold on, let me find the original thing. So the full thing is when behavior analysts enter into a signed contract to provide services to a client at the request of a third party, a school district, a government entity, they clarify the nature of the relationship with each party and assess any potential conflicts before services begin. So they ensure the contract outlines the responsibilities of all parties, the scope of behavioral services to be provided, the likely use of information obtained, any limits about maintaining confidentiality. Behavior analysts are responsible for amending contracts as needed and reviewing them with the relevant parties at the time. So I don't even know if we need to add anything about this. I think it falls sort of under, you know, various other sections regarding best practices.
Mm-hmm.
But if we do add something, this seems like the most relevant place to add it within this document.
Or maybe the AA should be replaced by the language that you just provided.
I just think that's way too detailed for
Okay.
a document like we're creating for the BSRB.
Right.
Or maybe just the language you put on the Excel sheet when entering a relationship with a third party. Because we are so confused about what AA, the original AA, is trying to accomplish.
Right.
I agree that I think Claudia's suggestion is great. It's separate from the current AA clause, and that if we don't have clarity on the function of AA, the current AA, that it makes sense to remove it and add what Claudia has suggested as just an additional clause unrelated to AA as it is now.
So removing what AA currently is and replacing it with when entering a relationship with a third party, ...
Yes.
So is that the consensus to go ahead and delete the previous language of AA and replace it with this language here?
So my only question with that is, I was looking back through the document itself, that KR 102-8-21, and K says, failing to advise and explain each client their respective rights, responsibilities, and duties involved in the licensee's professional relationship with the client, with L being description of the services, fees, and payment expectations, and M being failing to provide each client with a description of the possible effects of the proposed treatment, and N being failing to inform any financial interest. I just think that the changing it to what Claudia has here is a duplication of some of the previous statutes. Is there a way to just remove it then?
That could be done.
What do you guys think of that?
I'm fine with either one.
Linda, were you saying that there's a point that it point or a part where it specifically addresses third parties already? Because if not, maybe it just needs to be relocated to the area that you just pointed out because it falls within that, but it's specific I think third party.
Permitting a third party like Q2 is, well, like the whole like O is failing to inform that the client can receive services from a public agency, blah, 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 blah. P is copies of reports. Q is written informed consent with subset permitting a third party observation of the licensee's provision. And then due diligence, billing practices. So like the third party, if this is specifically related to third party, like I'm going to contract with the school district or I'm going to contract with the insurance company to provide services. Like that's the consent that you do at the beginning of treatment where they say, we're not just us, but your dentist office is, I'm going to share this information with your insurance company. I guess, or and I happen to be on the board of directors of United Healthcare. That would be the potential conflict, right?
I think it's also pointing out that if, you know, that the client is the primary or the individual receiving ABA services is the primary client. And if there's a conflict of interest between the contracting third party and the client, your primary client's best interest, that they're like what risks there are there and how to address those conflicts. It's kind of spelling that out clearly. Versus if you're just entering into a relationship with one client.
With a third party. I think the possible change from Claudia is clearer than the current AA. So if we're going to keep it in,
I agree that the third party is something a little bit different from what has described before, so maybe we should just add this one.
Are we thinking at this point about deleting the previous language of AA and just having this new language in its place instead?
Yeah.
Okay, any objections to that? Okay. There are still a number of different items on the agenda for the meeting today, and I think the hope is to have an advisory committee meeting in February. Normally this meeting would have been in December, but with some conflicts, we had to move it to today. So how about we go ahead and just pause where we're at right now. I do hope the next meeting we can go ahead and finalize the changes. And I did want to circle back around to the other Excel sheets that have been worked on with some recommended changes on those documents as well. So how about if we go ahead and just kind of stop
Hey,
the work
David,
on. Yes.
just so everybody knows, the Excel sheet that has my name on it, everything in that has been infused into my PDF. So you should have it listed here. So we don't need to review my Excel sheet also.
Okay, but that's great. Thank you. Okay, well, let's go ahead and pause here and we can pick back up here and then look at the other Excel document then when we meet again in February. So I'll go ahead and save and stop sharing my screen. And then Dave, if you're okay with this, we can go on to the next item on the agenda.
Yeah, very good. I had set my timer to 11:30 so that we had an opportunity to kind of make sure we caught up with some of these other items. The next item is a discussion of possible regulation for care of clients in crisis. Dave, do you have anything on that in terms of where we left that? I know there was a lot of discussion based on kind of the unique nature of the work done by people with this kind of licensure and the specific places they might be working, like in schools.
Yeah, I think part of this was that we were hoping perhaps there could be language that the advisory committee might be able to offer up in terms of this as it relates to their profession, and also making sure that individuals who may be seeking or may be in crisis after hours, that they have a clear understanding of what services are available as well. So we understand that the behavior analyst profession is a bit unique in certain cases from some of the other professions. So wanted to see if some of the advisory committee members had potential language they wanted to suggest or offer on this topic. Also, as far as whether there could be an existing unprofessional conduct regulation that could be modified, or perhaps if a new one would need to be drafted. That was, I think, part of the conversation as well.
So what's the language in that psych reciprocity? Because that would be a good one to have as a base. You know, the pact, the reciprocity pact with.
Well,
I think we're talking about two different things. Are we talking about the crisis or the reciprocity?
Oh, sorry.
Yeah, we're talking about the care of the clients who are in crisis after hours.
So, okay, sorry. I thought I heard you say reciprocity.
Yeah, I think there was an interest by the board in making sure we had language for the professions, outlining what a practitioner's responsibilities are when their clients are in crisis after hours, and
Okay.
seeing if we can adjust an existing unprofessional conduct regulation, or perhaps if a new one could be drafted.
That's what you said. Is there anything out there? I don't know how to draft that language. Claudia, Christy, Kim, Allison, Alice, Mike, do you guys have something at CASP?
Not currently, no.
So is the impetus for this, David, I'm just trying to understand. So is the impetus coming from like suicide prevention for folks seeking mental health services?
Yeah, I think part of this is, in some cases in the past, practitioners have said, if you're in crisis, you should call 911 or something like that. But with the launch of the 988 National Suicide Prevention Hotline, I guess one of the questions is it sufficient for practitioners to just have a message that says, if you're in crisis, you should call 988 or 911? Or is there something that practitioners should have a responsibility to make sure that they have, something in place to make sure that they're informing the clients, what resources are available to them? That's kind of one of the questions too. Do we need to add some language here that practitioners need to have a process in place to explain that to their clients, what resources are available? And then I think part of it too is, there was some language in there about continuation of care when you're taking over services. And part of it too was, in terms of should you be just volunteering your clients to somebody else, or do you need to have something more in place in terms of the transition of those services to another party?
I think that's the conversation that we had last time, because like a lot of behavior analysts, like especially if you're a center-based program, you work with the kids while they're there. If there's something that happens, you address it while it's there. But if it happens at home, then that doesn't fall underneath the jurisdiction of, Little Steps, or, that's something that you take care of at home. And so, and there's not a lot of individual providers out there that have the capacity to staff a 24-hour hotline with referrals for families, right?
Do we need to kind of narrow
So-
this?
Go ahead, Mike.
I was gonna say, do we need to kind of narrow the scope for which you all are responsible? Because, if it's a mental health crisis, that's not your area of expertise. But if
It may be for some behavior analysts, right? So like, I'm wondering, are there like, so just so maybe David is clear, like behavior analysts work with different populations. So I just want to make sure I'm wrapping my head around how the BSRB is defining crisis. So some people may work with people who have mental health issues. And so crisis might be suicide, right? Or ways in which they may harm themselves that could cause death or severe harm. For the bulk of behavior analysts, they work with people with intellectual and developmental disabilities. And so oftentimes in our field, the way that we define crisis is severe aggression, so ongoing aggression toward other people, or maybe what we call self-injurious behavior, where they may be headbanging or engaging in behavior that we would call crisis. And I'm not sure that the BSRB is categorizing that as crisis. So maybe just some clarification there, because it depends upon probably the population you work with, what you consider crisis, and the way that that's handled is very different depending upon whether it's the mental health folks or it's folks with IDD.
I think to add a little clarification, so essentially what has happened at this point is the BSRB had said, if a complaint was made in which the person said, I had a crisis and I tried to contact my provider and they were unavailable to me, or told me via an answering machine to call 911, that would be deemed unprofessional conduct. So the importance then for this group is to add some language that clarifies, maybe in those situations as you've described, Claudia, this is how we inform the people we work with about how to manage situations that occur after hours.
And I think
so it could just be providing some referral list or something like that for an individual.
The only thing that you can't do is make a referral to a group that doesn't know you're going to do that.
No, providing a referral list, or like a list of resources that the person could access.
I think part of the challenge is that, and we talked about it a little bit last time, is that if we have somebody that has behaviors that reach the threshold of intensity, that there may be a crisis after hours or on the weekends, that there should be a behavior intervention plan in place, right? That outlines what to do. And I think that, like, when you call your provider after hours or on the weekends or whenever it is they don't work in the middle of the night, and it says, if this is an emergency, please hang up and call 911. Because if I'm serving a client that's an hour away from where I live, I'm not going to get there in time anyway, right? And that family needs support now, or they should be following the behavior intervention plan. So I, you know, I think there has to be, you know, we don't want people abandoning clients after hours and on the weekends, because that's not best practice. But what would be best practice is that if we have a client that has behavior that meets that threshold, that we want to make sure we have a good function-based behavior intervention plan in place, and that the parents or anybody that's surrounding that individual when we're not there has adequate training on the implementation of that plan.
I was just going to say two things. One, I just recently had this happen, and it was during hours. The parent didn't know exactly who to reach out to. The staff that was with them couldn't answer the question. The BCBA was on vacation. And so the parent didn't even know what are the next steps. Who do I call? Who do I ask for? So number one, I'm thinking, you know, what is just the overall crisis plan in your business organization of the people that you're serving?
Right.
Number two, I'm thinking, you know, in all of our treatment plans, we should have a crisis plan. So typically at that end of that treatment plan, I've got my caregiver things, I've got my hours, I've got my coordination of care, discharge, transition. Then I have a crisis plan that says, if this hits this threshold, this is what we're going to do in this situation. So those are two things I'm thinking.
Mm-hmm.
Yeah, and it's different depending upon, maybe can it just be as generic that there is a detailed written crisis plan? Because in residential facilities, there are crisis management systems that have to be trained, and people who implement them have to be trained. And there's a process by which you implement different procedures, physical management procedures, de-escalation and physical management procedures for the safety of the individual. But it's different depending upon the population, depending upon, you know, the type of service being provided. So can it be generic enough that there's just a written crisis plan? Because it's going to be different depending upon where you are.
Mm-hmm. Everybody's shaking their heads.
And it can't simply be call 911, because 9 times out of 10, 911 responders aren't going to know what to do.
Correct. But sometimes it is 911. So if a consumer is going after a staff and they're the only staff in the residential home, sometimes the crisis plan is call 911.
Absolutely.
Which then means, like, if somebody calls KU Med Center and they get, you know, a number, it's like, if this is an emergency, call 911, right? Because KU Med Center, like, if we're off, I'm not sure that KU Med Center for our kids in our bridge clinics here, or even our parent training clinics, that they would try to get in touch with one of us off duty. We don't have pagers, right? So,
And I also definitely have had parents of children with severe behaviors. They have to take their children to emergency room.
mm-hmm.
So that's another place that sometimes they go.
I'd like to ask for more clarification, because when this was originally brought to us at the last meeting, David, it felt like the way things were phrased was that this needed to be addressed, and that the current kind of standard operating procedures were inadequate. Whereas the way the notes are written, it sounds like this is just a conversation to be had. It's receiving additional interest in terms of addressing mental health crises. And so, David, you were saying that just saying call 911 is inadequate, that we can't refer to someone who doesn't know that they're going to receive that referral. So where is that information coming from that those are inappropriate responses to clients in crisis?
So I think part of this has to do with the recent rollout of the 988 National Prevention Hotline. And it's kind of brought into question kind of a larger conversation about, what are practitioners' responsibilities in terms of having a plan in place, and then what is their responsibility in terms of advising their clients in terms of resources that are available. So, so part of this is making sure each one of the advisory committees discusses this and then tries to offer, for some of the advisory committees, it's possible that the language in their unprofessional conduct regulation might be sufficient to cover something like this. But I think for most of them, there's probably needs to be some additional clarifying language to kind of give, because I think what the idea is that you want to provide specific enough language so that practitioners know what their responsibility is on this topic. Ultimately, for there to be a violation, it would need to go in front of the complaint review committee. They would need to weigh everything. So it's really hard to say what exactly would constitute a violation because each is case by case basis. But the existing language really probably isn't specific enough to outline, what is a practitioner's responsibility. So that's kind of why they think there was a call to maybe change the language or add new language on the topic.
But it seems that, oh, sorry, go ahead.
I'll add a little clarification, just because some of this really actually started before Dave joined the BSRB staff, that it became apparent that some CMHCs were being used as people's crisis referral. Just private practitioners were saying, if you have a crisis, call the CMHC. So that issue was referred to the board prior to my time being on the board as well. The board looked at that situation and deemed it as unprofessional conduct to have your crisis be to send the person to someone who doesn't know that they're in that role. Now, if they had an agreement with that group to say, yes, we'll manage your after hours or your crisis contacts, then that's fine. So then to Dave's point, part of what BSRB's role is to create rules and regs so that people understand in each profession what their responsibility is. You don't want them not knowing that they need to do something, right? And then do something as part of their professional conduct and somebody say, well, this is unprofessional. But also to Dave's point, you can't, like in some circumstances, if somebody was being physically assaulted and you said, call 911, that's extremely appropriate. But if we just told a parent in every circumstance to call 911, then I'm assuming the BSRB would look at that and say, no, that's not an appropriate response. So having language that says there needs to be the development of some kind of plan is kind of, I think, what Dave is referring to when he says each profession needs to provide some feedback to BSRB. Otherwise, the risk is that the board will just pass some language that won't fit very well for your particular profession.
I don't know the answer to this, but I would imagine that, given a situation where it's in the middle of the night and or, the attending clinician is out of town for a week, should there be some provision to address getting historical records to the place that it's being referred to in a timely manner, because some of your cases are probably so complex that without having that historical record, it'd be very difficult to treat.
Yeah, and I'm just thinking of, just coming back to our field BCBAs, right? And people that are single BCBA with a handful of clients, and their ability to staff a hotline 24 hours a day, 7 days a week, 365 days a year is not practical. And if we have something in regulation that they have to be on call, that during that whole thing, they're going to go out of business, and we don't have enough people as it is.
But wouldn't a group that you just described probably wouldn't be seeing the more intense
they may or may not, like maybe that's their area of expertise. I'm like superimposing on Claudia. Claudia decides to retire from KU and go out on her own, and she's going to accept like 2 clients, 3 clients, because she's got expertise in conducting FAs and dealing with those really high intense individuals, right? We still can't expect Claudia to be on call 24 hours a day, 7 days a week, 365 days a year. And so, and I just come back to, I'm projecting onto you, Claudia, that you would have a function-based behavior intervention plan in place with subsequent steps outlining it. And so then it comes back to so what the main office number now says, if this is not during normal working hours and you are having a behavioral escalation, refer to your behavior intervention plan and if someone is in, so now it gets really wordy, right? If someone's in immediate risk of death or dismemberment, please call 911. I mean,
So as a reminder, BSRB's primary role is the protection of the public, right? So whenever we come to advisory committee meetings or BSRB board meetings, we put on different hats, right? We're not there thinking about necessarily like my job, my profession, my group. We're here to think about the public and how to make sure that they're protected so that when they come to a BSRB licensed professional, that they are getting the best services and that we are making sure we have regs in place that protect them.
and I totally understand that, David Anderson, not David Fye. But if we don't have any service providers because they can't meet the regulation, and I'm not saying that's hyperbole, right? But if we have service providers that are dropping out of the field because they can't satisfy this requirement, then we're not.
That's why we're asking for the group to create some specific language that would fit. So in some states, as Dave knows, each profession has its own board and can create its licensure that's very specific to that profession, or maybe a standalone social work board and a standalone psychology board. BSRB is kind of unusual in that it covers so many different professions, which is why there are advisory committees and why we come to those groups and say, help us make sure we're crafting language that does fit. So again, that's the task that's being brought to you because you're the experts in balancing these two things, but primarily our role here, as opposed to, the Kansas Association of Social Workers, who has a whole different task. BSRB's task primarily is to protect the public and to have language in its regs that is understood by the practitioners so that if somebody makes a complaint, the complaint review committee can look at that and say, here's what it clearly says. Does this fit? Did they do what they were supposed to be?
So is the regulation a is it going to be a BSRB wide regulation, or is it we need to create it specific for our different areas?
I think the topic will probably be BSRB wide. I think if there is specific language based on uniquenesses per profession, we can definitely have some different language for each of the professions if there's some reasons why it would need to be worded a little bit differently.
Gotcha. So I guess what I am wondering is we're sort of starting without any examples or any information about what this looks like. I'm wondering, can it just be a blurb? Does it need to be some kind of detailed document, a bullet point list? Because it sounds to me, based on what everyone's suggesting, with respect to best practices, that there's a written plan and that there are resources that people can access, period, with respect to crisis. And whatever that looks like in a different population or in a different environment can be different. So I guess that's what I don't know is how specific do we need to be? Are there any examples from other states or other things that we can look at?
So a few of the other advisory committees have discussed this topic, and I could probably take the language that they have discussed so far and bring it back to the next meeting. So maybe that would be helpful to kind of share at the February.
That'd be great. Thanks, David.
The other thing I can do, GASP is in the process of developing the third edition of the ABA practice guidelines, and Judith is leading that up. So I've reached out to her to see if perhaps that's something they're addressing, because I suspect it might already be on their radar to include.
That would be awesome, Mike.
That would be
And
awesome, Mike.
Dave, I have a hard out in 3 minutes.
Okay.
All right, and I just want to say one more thing about this topic is that most of us are not in the crisis industry, meaning people don't call us only when they're in crisis, like they would call the suicide hotline, or they, you know, most of the people that would be calling us because their consumers are in crisis would be existing consumers. And I think that probably makes a difference on the voice recorder as well for after hours and on the weekends. Looks
Okay.
like.
Okay. Well, really good comments from everybody. I know we're running about up on time, so we'll have to continue this the next meeting. I know, Dave, you mentioned you have a hard out here in a couple of minutes. I just want to, under new business, there was an item on a possible reciprocity statute. You mentioned currently there is no reciprocity statute for the behavior analyst profession. I think given the short amount of time, we probably wouldn't be able to get something into statute on that for this session. But as it relates to reciprocity, I think I mentioned earlier, one of the items the board was focusing on was perhaps reinstatement language to allow individuals to come back to the profession. There's also no language on reinstatement for your profession as well. So if individuals do want to become licensed again, they actually have to get a new number, and it's essentially a new card when they get licensed again. So just kind of wanted to discuss that with you and see if you would be in favor of it. Maybe adding some language to parallel the other professions as it relates to reinstatement. That way we could put into place the same language as the other professions. We might have one more board meeting before the legislative session really gets into full swing. And if we have that opportunity, I'd like to go ahead and have language added for your profession. So that way you would be able to take advantage of that reinstatement policy the board had recommended for all the professions. Would you all be in favor of something like that if there was language added to statute for a reinstatement of licenses?
Yeah, can you, is that again something else that you could give us a sample for?
I mean, basically the language would just say that, it would mirror other language in other professions, so that if you wanted to reinstate your license, if it was within the year of it being expired, you would have to pay the regular fee plus the reinstatement fee. But if it was over a year, and if you'd already been out of practice for a year and you wanted to come back, then you would be able to do it for half the cost. And you would be able to, you'd have to get all the continuing education hours for the past licensure period. But you could do that short-term temporary license like the other professions while you're doing those hours if you wanted to pursue that. So it'd be essentially as close as possible, identical language to the other professions on that topic.
This would be good because I've run into where a BC ABA didn't renew her license literally the day after, and she had to get a whole new license number, which means we had to update it with all of our credentialing and all of that stuff too. So be very nice to have.
That's what I was just going to point out, that every time they have to get a new license, they get a new license number, and that's not as easy to track for clients either.
And for the public, it could be confusing if two people, someone has multiple license numbers. So it'd be good for public protection to do this too. So,
And if and I don't know how it's it happened to me like back in 2010 with my psych license, where my office manager hadn't submitted the application, and I found out about it 2 days afterwards, and it turned into this whole big thing. And so now when you look at it, it's like my original license expired. And then, so now it's got implications for insurance because you had to be in practice for 5 years. And so.
Yeah, I think this will be a good change. If there's no objections, it seems like it's consensus to go ahead and support it. So we'll forward that recommendation to the board. And
And Dave,
go ahead, Dave.
will you send out a doodle poll for the date for the next meeting?
Yes, I will do that.
Great. All right. Just under the wire. Thank you all very much for your time. Hope you have a wonderful new year. And Dave will send out a poll to figure out when we will meet next month, which will get us back on our normal schedule. Thank you all.
Bye, everyone.
Happy New
Bye.
Year.
Bye.